Thank you very much. So the topic I'm addressing today is the HCCH principles in the modernization of national and regional laws. As you already know, the core members of the working group, headed by Professor Daniel Giesberger, have prepared this choice of law in international commercial contracts as a commentary of the HCCH principles. It's been published by OUP last year, and this thick commentary covers actually 20 jurisdictions from Asia. So we had a very wide contributions from Asia, fortunately, and that shows that many academics are very much interested in taking part in this kind of international work. And also many publications are being made in this area. So, for example, if you take a look at recent publications, we have a series of books on private international law in Japan, in China, and also in Vietnam, Indonesia. And this new book on unraveling choice of law in international commercial contracts, that's a PhD thesis submitted to the University of Rotterdam. And this is an excellent book on the analysis of international commercial contracts in Indonesia. And also we have a book on Indian private international law, as well as private international law in South Asian states. So Asian states have become quite active in this field, and we have been working quite hard to publish books to present the private international system that exists in the region. If you take a look at diverse jurisdictions in Asia, you will notice that we have a large mixture of various legal systems. So we have civil law systems, common law system, and some mixed legal systems, as well as state law system and customary law system. And there are also states or jurisdictions that have both secular law or religious law. So by taking a look at this diverse picture of jurisdiction in Asia, it's very useful to do a comparative study in these fields. And particularly, we will also notice the differences in choice of law in contracts. So in thinking about whether future harmonization of private international law in Asia may be possible, it's definitely important to know what the Asian legal systems have as conflict of laws rules. In this respect, I think I'd like to point out several important aspects where the HCCH principles may well serve as an important inspiration in developing our legal systems. So then HCCH principles address the choice of law in international commercial contracts. And the principles have important rules with regard to choice of law by the parties and the modality of choice of law and the scope of application, and several other important rules are included in the HCCH principles. When it comes to party autonomy and the freedom of choice of law by the parties, we notice a diverse picture in Asia. So first of all, there are still some jurisdictions that are reserved toward party autonomy in litigation. For example, in the case of Iran, party autonomy is still limited and is only allowed for contracts between foreigners transacting in Iran, according to the author contributed to our commentary. If we take a look at the Middle East, again, a number of jurisdictions require an objective connection for the law to be chosen by the parties, except the Dubai International Financial Center and Lebanon. And for Egypt, it's still disputed among authors. And even if and foreign law has been chosen by the parties, in the court proceedings, proof of foreign law may be required by the judge, so it's still a burden for the chosen law to be applied by the judge. In the case of Indonesia, again, for the applicable law to be chosen by the parties, substantive connection between the contract and the chosen law is required unless there is a reasonable ground. For example, in the case of aviation contracts or shipping contracts, this kind of protection is not required, but otherwise it's still necessary. And then the Indonesian authors report that courts may not apply foreign law, even if that law has been chosen, because the Indonesian courts have in the past denied jurisdiction or characterized the issue not as contract but as tort, or in some cases, choice of foreign law has just been disregarded and the Indonesian law was still applied. So although other Asian jurisdictions have principles of unrestricted choice of law, considering that some other Asian jurisdictions are still reserved toward party autonomy in litigation, the HCCH principles may well serve as an important guiding principle and to promote party autonomy. So under the HCCH principles, Article 2 provides for a choice of law, and paragraph 2, it allows depassage, so a partly restricted choice of law only to the part of the contract is also possible, and the modification of choice of law afterwards is also possible. And paragraph 4 states that no connection is required between the law chosen and the parties or their transactions. So this kind of general principle may well be useful for some Asian jurisdictions. When it comes to the explicit and tacit choice of law, the HCCH principles provides for in Article 4 that both explicit and tacit choice of law are possible. And then when it comes to some Asian jurisdictions, it is interesting to see that mainland China, Taiwan, and Dubai International Financial Center do not accept tacit choice of law, but the choice of law by the parties must be explicitly stated and to make sure that the certain law has been chosen by the parties. Other Asian jurisdictions, so the majority of the jurisdictions in Asia accept tacit choice of law. So in these jurisdictions, it is considered to live up to the parties' expectation to accept also tacit choice of law, and even if the parties have not expressed their intent explicitly, it can be equated with an explicit choice of law if the parties' intent is obvious. In the case of Japan, party autonomy has been accepted since 1898 from the old Horay statute. And until today, party autonomy governs and is the main leading principle in international commercial contracts in Japan. However, under Horay, we had the problem that in the absence of choice of law of the parties, the objective connecting factor was the law of the place where the contract was signed. So whenever there was no choice of law, the judge was forced to apply the law where the contract was signed, which could be determined fortuitously. And this is why the judge started to extend the parties' intent very broadly in order not to be to have to apply the law of the place of the conclusion of the contract. So when our statute was reformed in 2006, we academics advocated that the parties' intention must be limited to the real intention without including presumptive intentions. So for us, it was important to clearly define the tacit choice of law and limit it clearly to the parties' real intention. And fortunately, recent case law has been developing and is becoming better, and when there is no real intention of the parties, the judge switch switches to the closest connection test as the objective connecting factor. In defining the tacit choice of law, I think Article 4 of the Hague Principles is very helpful because the official commentary gives clear guidance when clear intention of the parties can be accepted. For example, when a standard form is used in the contract, like the Lloyd's insurance contract, then the choice of English law can be clearly assumed from the contract, or use of a language proper to the certain legal system can also be considered as an tacit choice of law. So by having this kind of guidance, I think we can improve our domestic choice of law rules and give clear guidance when there is a tacit choice of law. One of the main points of the HCCH principles is that they allow the choice of non-state law in Article 3. By surveying the comparative choice of law, particularly Bahrain and Qatar are ready to accept choice of non-state law, which is also the case in Paraguay and Uruguay. Most jurisdictions, however, do not accept choice of non-state law in litigation, but only in arbitration. So when there is no choice of law, non-state law as conflicts rules, then there's only incorporation of the non-state law into the contract. However, academics in Japan are becoming supportive of the choice of non-state law, also for litigation, because it's an expression of party autonomy and ensures neutrality and choice of advanced rules and ultimately consistency with arbitration. In Asia, Islamic finance plays an important role in many jurisdictions, and selection of Sharia is considered as an important principle. So in the 2008 Malaysian Court of Appeal decision, the state court clearly gave preference to the religious court's interpretation of Sharia. So when considering the important role of Sharia in many Asian jurisdictions, Article 3 of the HCCH principles that provide for the choice of non-state law plays an important role. And then at the same time, Article 3 provides for that rules of law that can be chosen are generally accepted on an international, supranational, or regional level as neutral and balanced set of rules. So this definition may be too narrow, and then in light of the necessity of the practical application of Sharia, maybe we need to broaden the scope of the eligible non-state law in Asia. By looking at these kind of developments in Asia, we academics started to form a group and to develop Asian principles of private international law. So we do comparative studies and try to bridge differences among Asian jurisdictions to think about possible rules that can harmonize the choice of law rules and other jurisdiction rules and so on that exist in various Asian countries. The work itself started in 1997 as a bilateral exchange between Korea and Japan, and it's been extended to other Asian jurisdictions recently. We have been working on contracts and torts, choice of law and jurisdictions and judgments recognition. Unfortunately, we have not been able to publish Asian principles so far, but this year, our leader of the group established Asian Private International Law Association. So we will continue working on these principles, and hopefully we can materialize the principles and publish them soon. Then Asian principles have a broader scope than the HCCH principles, so we try to cover the entire areas of private international law. And this is because Asian jurisdictions have diverse private international rules, and at the same time, there are not yet uniform private international instruments, except for some HCCH conventions, such as child abduction conventions and inter-country adoption conventions. So in order to fill these kind of legal gaps and enhance mutual understandings, we academics are trying hard to work together. As for choice of law in international commercial contracts, we have very much relied on HCCH principles with only slight deviations. So for example, for the choice of non-state law, we ultimately decided to delete the part that rules of law need to be neutral and balanced set of rules, because some members expressed a concern that if we have this provision here, the judge may use it to deny the application of non-state law, because these set of rules are not neutral or balanced. So this is why we decided to delete that part and try to accept the choice of non-state law in a broader scope than the HCCH principles. We also include some provisions in the absence of choice of law, and which is based on the closest connection test, and the presumption of the closest connection is based on the characteristic performance of the contract. So we are still working on these principles, and hopefully we can finalize them very soon. As a conclusion, HCCH principles have been adopted already in Paraguay, Uruguay, and Mozambique is also considering that. And hopefully they also will inspire other Asian jurisdictions in the future. When it comes to choice of law, it is definitely important in digital economy, because when we think about smart contracts, for example, it's no longer possible to localize the contracts in one state. But we have to rely on the parties' choice of law. And for dispute resolution, particularly arbitration, mediation, and ODR, choice of law becomes important. In this respect, HCCH principles will play an important role. For future work, HCCH principles in the absence of choice of law would also be very useful in order to overcome divergent rules that exist in different countries. So we hope that the work of the HCCH will continue and further develop important instruments. Thank you very much for listening and for your attention.